Okay, so we've been talking about what lawyers and judges call the Dormant Commerce Clause, although there is actually no Dormant Commerce Clause in the Constitution. There's only a Commerce Clause in the Constitution, right? So I tend to call it Dormant Commerce Principles, but that doesn't matter. You can call it whichever one you want. The idea, let's never lose sight of, right, the fundamental guiding principle, right, that's in play here, is that the constitutional grant of power to Congress to regulate interstate commerce, right, is a negative on states, right? The reason why the founders transferred that power from states to the federal government, right, in Congress, was to stop states from engaging in trade wars and protectionism. And you got to keep in mind what protectionism means, right? I've got a slide here. If you look at the bottom of the slide, for the time being, it mentions what protectionism means. Protectionism means a state, right, favoring in-state private business interests over the interest of private business interests, right, elsewhere, out of state. So, and just think about that for a while, right? I mean, that's what protectionism is, right? It's the government trying to give, not itself, but to give private business interests, within the government's jurisdiction, an advantage over business interests elsewhere, and an unfair advantage in most cases. So, for that reason, states are not supposed to discriminate against interstate commerce. It's funny how every time I say what states are not supposed to do, the dog starts barking. I think she knows, right? Bad. Discrimination against interstate commerce is bad. That being the case, right, hackles up, like the dog, right, and strict scrutiny applies. So, and you know how that works, right, narrowly tailored to a compelling interest. Now, what we're talking about here is, right, exceptions to the application of strict scrutiny when a state discriminates, and it seems to be discriminating against out-of-staters, right. So again, I'm going to refer to the slide here as Lainey plays with her squeaky football. Okay, so a state or subdivision, this is when strict scrutiny does not apply, right? When a state or subdivision is discriminating in favor of in-state interests while participating in a market, right? Instead of regulating, participating in a market, right? And as we learned from the Alaska timber case, so that's from the South Dakota cement case, right? From the Alaska timber case, we find out the next part ends, right? You have to make sure that the state is not reaching outside its own market, right? In other words, upstream or downstream markets from the market, right, that the state is in. So Alaska is in the lumber selling or timber selling business, right? So therefore it can decide who it's going to sell to, but it cannot regulate beyond that, right, to a point where now they're regulating the processing, right, lumber processing market. So that's called the market, the market participant exception. If the state is participating in the market, the state is allowed to discriminate against out-of-staters with regard to the market it is in. And as I said in the last video, this is not that difficult of an issue to spot, but you have to know what you're looking for, right? What you're looking for is the state or a subdivision of the state is in business, right? They're in business. They are, right, they own a cement plant, right? Or they own the timber, right, and they're selling it. So, okay, then that brings us to the case that I've been saying in previous videos. I'm not a big fan of this case. It really kind of muddies the waters, but we have to deal with it because it's out there. And that case is the United Haulers case from your reading. It just so happens that one of my former colleagues and a good friend of mine has written one of the leading journal articles about that case. He was kind enough to help me figure out how to teach this because I was struggling with it for a while. It boils down to this. What we've been talking about. Oh boy, here we go. All right. Lady, can you put that down? Okay. Okay. When the state discriminates, right, in favor of in-state private interests, it violates the dormant commerce principles and strict scrutiny applies. On the other hand, when the state discriminates, or a subdivision discriminates in favor of itself, that is not a dormant commerce clause violation. So let's talk about what happened in the United Haulers case. In United Haulers, you have a municipality, so a subdivision of a state. And the municipality enacts what's called in the law because this happens, this is not the first time this has happened in a number of cases, a flow control ordinance, right? That's what my little arrow here, that barely visible arrow here is designed to represent, right? The ordinance requires, and what we got here is, right, basically the Sopranos here, right? The garbage waste disposal industry has been infiltrated by organized crime. There's all kinds of trouble. Local governments, state and local governments are trying to deal with the problem of organized crime in the waste management industry. And one of the ways they're going to do that, right, is this municipality says we're going to have a flow control ordinance that, right, any waste collection, business out there, when you collect your waste, you have to bring your waste, right, to be processed at a municipal authority, okay? So that takes away your discretion if you're a garbage collector of where to send the waste, right, for processing. You have to send it to, it's flow control, right? The flow of waste is directed to one particular place. If it's collected within that municipality, that's where it goes. It has to go to a municipal authority, right, which is a municipal corporation. This is critical, right, for processing. It can't go anywhere else. Now, of course, what's going to happen is that processing, right, businesses outside of the city are going to say that's a dormant commerce violation. It discriminates in favor of an in-city, right, processing authority. What the Chief Justice Roberts says in that case is that the controlling fact, right, in the case is who the policy, right, discriminates in favor of. He says, in most of our dormant commerce cases, the problem we have is with a city, right, passing an ordinance or a state passing a law that favors in-state businesses, private businesses. In this case, the authority to which the waste is directed, right, the flow is directed, the authority to which the flow is directed is not a private business interest. It is a municipally controlled authority, not a private business. And in that case, Robert says there is no dormant commerce violation. So you need to be aware of the United Haulers case. And again, backing up to our slide here with basically the two exceptions to strict scrutiny, so I hope this is making sense. Once you see a state acting in Con Law 1, you think, I think I'm being tested on dormant commerce, right? If it's an essay question. So state of Florida, you say, boom, that's probably a dormant commerce question. Next, you see that whatever the state of Florida did had some impact on interstate commerce, and now you know you're being tested on dormant commerce, right? Then you got to figure out, was this purposeful discrimination, right? Or was it not? And if it was discrimination, and we're going to have to do one more case about that in another video, but if it was discrimination, then you apply strict scrutiny. If it was not discrimination, then you apply Pike, right? If the impact on interstate commerce was merely incidental, meaning basically accidental, right? That it wasn't on purpose. If the impact on interstate commerce is incidental, then you apply Pike. Now, what we're saying here is there's one other layer that you have to unpack, and that is when you see discrimination, you have to check, right? If the state is discriminating against out-of-staters, is the state in business? Okay, and it's discriminating against out-of-staters in terms of the business that they're in, who they're going to do business with. You can think of it that way. I just thought that, right? If the state is in business, they can decide who to do business with, right? But they can't regulate upstream or downstream from their own business. So watch out for that, right? That would lead you to a discussion of market participant, and of course, multiple choice questions on the bar exam can cover that as well. The other exception is United Haulers, where this is pretty straightforward, again, but you have to know what you're looking for, right? If you see a city or a state discriminating against out-of-staters or favoring, right, an in-state or in-city interest, just make sure that that's a private business, right, before you apply strict scrutiny. If the state or the city is discriminating in favor of its own, right, its own authority, and I put here, look for agency or authority, right, some kind of agency or authority that belongs to the state, a state agency. If the state is discriminating against out-of-staters and in favor of a state agency, or a municipality is discriminating against out-of-municipality-ers, right, out-of-cityers, right, in favor of a city authority or a city agency, right, those are not dormant commerce violations, right, and you're not going to get strict scrutiny on that. So your flow chart, you see the state acting, it's probably a dormant commerce question. You see that there's some impact on interstate commerce. Now it's a dormant commerce question. You check for discrimination. You apply, if you find it, then you apply strict scrutiny. And discrimination just means treating in-staters and out-of-staters differently, favoring in-staters at the expense of out-of-staters, or in-cityers at the expense of out-of-cityers, right? If you see that, then you apply strict scrutiny unless, okay, I guess you out there drawing your flow charts, unless the state is a market participant, right, or is discriminating in favor of itself, or both. But those are two separate exceptions that you want to look at: market participant and United Haulers. That brings us to the end of this video. We got probably a little bit more dormant commerce to talk about, and then we'll get to some other issues like the Privileges and Immunities Clause and the Contracts Clause, and then move on to some actually more kind of fun topics like procedural due process, and state action and that good stuff. So that's enough for this video. Stay safe, and I'll get another one up here pretty soon. Talk to you later.